Hello, hello. Welcome, welcome. Again, we're going over some forms. I'm going to kind of go over a global view of these forms today because I kind of want to touch base on why they're important to us. We've got financing, inspection, homeowners insurance, and the listing agreement. Those all had changes, and so that's why I'm going over these particular ones at this time. Hi, Jamal. Okay, I'm going to go ahead and share my screen. Make sure I find the right one. There it is. Okay, I'm going to shrink you guys down here. Okay, the first one is our inspection form. So remembering that this is a buyer get out of jail free card for buyers that have an inspection contingency. I had an example today in one of the offices where the buyer had an inspection contingency and they got cold feet. And the listing agent said, oh, just rescind your offer by using a Form 51. So for anybody that's never heard me say this, Form 51 is a bad form. 51, think of Area 51, bad area. So making sure that you do not use Form 51, which is a rescission that needs to be signed by all parties. You do not use that form unless you ask me first, and that could be your only option. I would say maybe about 1% of transactions throughout the year, you will actually use a 51, but I need to tell you if that's okay. If our agent had used that and the seller never signed the 51, which they have to, it's not a termination, they have to sign that. If they didn't, and we go past our inspections, we go past all of our timelines, the buyer will lose their earnest money. So I made it very clear, especially in this situation today, that our broker should not have used 51, and she didn't. And the other broker's like, well, I need you to use that. I'm like, no, you don't. So make sure you always check with me first. So but this is a get out of jail free card. A buyer can terminate for any reason. They don't even have to have the inspection, which our client had not had that either. You can terminate for any reason, whether you've had the inspection or not. The there's no limit on the number of inspections and evaluations that your buyer may perform. Seller needs to know this. Buyer must know this. Buyer's obligation is to fully perform their due diligence. So that's the importance of this form. There were not many changes made. One of them had to do with adding the OSS conversation here about being able to have that line, the septic line inspected. They added additional language that bids are allowed to be used on a Form 35R, that the inspections can be of any inspections that they want it to be. Okay. Oh, this is right. Sorry. And this is also a contingency, which is a legal excuse for the party's failure to perform the terms of the contract will allow them to potentially get out of the offer. Sorry, people keep coming into my room, so I have to let them in. I apologize. Okay. So this is a contingency. This gives a buyer a right to terminate the contract. So this is contingent upon the buyer's sole subject satisfaction. Again, you do not have to have an inspection in order to terminate the transaction as long as you are within your time periods. Okay. Making sure, which I tell this to everybody in your buyer consultations, it is a time for you to have the conversation. Buyer, we are buyer beware, buyer due diligence state. So you, in your best interest for you, is to have your own inspection. I am getting a little perturbed when listing brokers will say, I want you to do an inspection before you make an offer on the house, even though you're not in a multiple offer situation. That is a cost to a buyer that I don't think is necessary, because if they were to have that inspection done and they've waited now to write an offer and somebody else comes along and they get toasted by not able to actually have an offer submitted because they accepted one from somebody else and they leveraged your buyer as, oh, we've had pre-inspections, like this house is so fabulous and multiple offers. I don't want that leverage to ever be given to a seller based on your buyer. It may, without limitation, include structural, mechanical, general condition of the improvements to the property, compliance with building and zoning codes, and inspection of the property for hazardous materials, a pest inspection, and soil stability inspection. Be very careful with the soil and stability inspection if there's an oil tank situation of the property. If your client is buying a property with an oil tank, whether decommissioned or not, come see me before you get too far into either the inspections or the offer so that we have a chance to discuss what can happen and what you can and cannot do to share with any seller and what that really means. Buyer's general home inspection must be performed by the buyer or by a licensed person under the RCW, but can include plumbers, electricians, roofers, etc. So when you're in your consultation, it's a time to talk about the importance of an inspection, and buyer, you must interview your inspector, you must hire your inspector, and you must pay for your inspector. Those are your three things, buyer. So when the time comes that we're writing an offer, now we've reached mutual acceptance, you will have either interviewed the three that I gave you on my Form 41D, which is a referral of inspectors' relationship disclosures required by state law. Anytime you refer an inspector, the firm's policy is a minimum of 3 inspectors must be on there, that you are to always give it to them in your disclosure packet, the Keller Williams disclosure packet. I recommend, if you have not filled that out and created your own signing block for the disclosure packet, I recommend you do that today using Transaction Desk, downloading, re-uploading. It's up to you. The disclosure packets are both in the hub and in Transaction Desk templates. But fill that form out, because you never know. Well, my buyer isn't going to have an inspection. Well, they might change their mind, or maybe they don't get this house and the next house they do want an inspection. Have that form ready to go. Minimum of 3. So, buyer, your job is to interview any inspector you want to use. Here's 3 with my relationship disclosure that you can actually call if you don't have one of your own or referred by another person and gives you one. When the time comes we reach mutual acceptance, you are going to call that inspector that you chose. You're going to 3-way call us in, and we will get our calendars all out and we will schedule that together. That is how that conversation should go. I do not want to ever hear, well, I called this inspector because my buyer. No, we don't call the inspector for our buyers. Our buyers schedule their own inspections and they interview those inspectors. So again, during the sewer scope, if you're on an OSS, which is an on-site septic system, there is a chance to view the line, a scope, and that is it. Make sure that you do not use this inspection form to be your only inspection form for septic. Septic has their own contingencies and has very much stronger language and more opportunity for further investigations for the buyer. Make sure when you're looking at your septic addendums that you look to make sure that you're in the correct county. Snohomish, as an example, is just 22S. King County has their own, Thurston, Pierce, and a few others. Whatcom, make sure you pick the correct form. This, again, is buyer is solely responsible for picking, interviewing, and doing all of the things for our inspector. The contingency shall be deemed waived, and seller shall not be obligated for anything, whether it's repairs or modifications to this agreement, if this day filled in here has passed. So if I stuck with the default of the 10 days in here, on the 10th day, and you have to remember your computation of time, 5 days or less or business days only, cannot count or end on weekends and holidays. 6 days or more, count the weekends, but cannot end on the weekends or holidays, but it counts them. So by the 10th day in our scenario, by 9 p.m., that's when it ends. Our time period ends at 9 p.m. The buyer must have served notice to the seller. I want additional inspections because my inspector recommended it. I want repairs or modifications done to these items in the house, or I want to modify our agreement with either a purchase price change or
not necessary, but if you want to bring them in, the seller will not be.
Sorry, I had to mute somebody. Or ask for credit costs, closing costs, excuse me. However, if you are going to ask for closing costs, please remember that if you already have closing costs given to the buyer based on their financing contingency, we're going to see that page as well. Or maybe your compensation is different. You're utilizing Form 41C, which states that seller is paying 3%. I charge you 2%. There's a 1% overage. We're using 41C to disclose that the seller is now going to give the buyer a 1% in credits for closing costs or a modification in their price. Make sure that you do not go over whatever the lender has agreed for a seller or anybody in the transaction to pay closing costs on behalf of your buyer. Never, ever, ever, ever share the inspection report, paragraph 4, with the seller's side unless you have received a Form 35C consent for buyer to share, seller has signed that. Don't get tricked by a listing agent that says the seller would like to see this, and maybe they text it to you. They figure this is consent, this is in writing. You need the seller's signature. A listing agent cannot ask for it without the seller signing a consent form. I don't want an email from the seller. I don't want a text message from the seller. I want Form 35C used for this purpose. If you do share any portions of it without consent, you have now waived your buyer's inspection contingency. So making sure that we don't do that. If for some reason the seller decides they do want this before you even had your inspection, buyer, they can check one of these boxes and it will not be considered a counteroffer. I do want them to initial it because I want to make sure that there's a proof or string of proof that the seller did consent to this. I recently had in one of our offices, the seller is a licensed broker in the state of Washington, also holds her lender's license in the state of Washington. We were the buyer side. We sent over a request for change of lender, and we put about a 4-point addendum together that the seller would agree to. They signed it, but they added 0.5 that said earnest money released and non-refundable to the seller, something of that nature. We never signed that counteroffer. They sent it to escrow. Escrow immediately released the earnest money, and it was not agreed upon. And based on that being fraudulent, we're going after that person and that firm in a legal manner. So don't ever add anything without somebody signing it for the security of making sure it is purely agreed upon. If your inspector buyer has said, I recommend you have additional inspections of X, roof, electrical, whatever, and you didn't have that done to begin with, then you are allowed to have, as long as the seller signs this, the default is 5 business days. You can have additional inspections of these items. So you can schedule as many as you need. What I recommend is whatever contractor that's coming out, an electrician, a plumber, if it's general or roofing, that they do a bid for you, because that's how you're going to ask the seller for remedies to the items that need to be repaired. If the inspector did not recommend additional inspections, you cannot have additional inspections. And when you look at Form 35C, you will note that a seller's option is, I just want to see that your buyer's inspector actually did recommend additional inspections. And I'm going to tell you right now, listing brokers, I don't care why they do that. I think that it's just something that's petty. Let them do what they need to do to have additional inspections, okay? Don't get caught up in the weeds and emotional over any parts of this, please. Buyer's request for repairs or modifications. If buyer requests repairs or modifications, then the parties shall agree and set forth using Form 35R. If for some reason paragraph 5 is in play, so you are now having additional inspections, then you are going to send Form 35R prior to your expiration date up here to the seller. That will complete that 35R. That one now is done. You keep it in your transactional folder, which is for us is in command, and you keep that for us. Now we're asking for repairs based on the bids and everything that we'd received. Now we're going to get a new 35R out, and we're going to start to tick off which box applies. I want the seller to do X. And that's going to be, if you're doing bids, you're going to have language about that. I do have the language for that. That you're welcome to use. Please text me with your name in case for some reason you're not on my phone. If you want the language for that, I'm happy to share. Then the seller has up to 3 days to respond to you. What happens if the seller doesn't respond to you in those 3 days? You automatically go down to buyer's last time period, which again is 3 business days to come to a agreement. So if you're down at this part and you sent stuff, but the seller never responded to it, and you come down to paragraph 6B, this is when I get on the phone with the listing agent saying, listen, my buyer wants to move forward. However, we need this, or this done. Is your seller agreeable to any of this? We'll put this in writing. And maybe you start negotiating verbally, and then you put it in writing on a 35R and potentially a 34 if the language is too long, and get that before this last time period. These last 3 days at 9 p.m. If you do not have a written agreement, buyer gets nothing and their inspection is waived. So it's very important. These time periods do not repeat. You may need to add language for an extension. If you do, let me know. If the seller agrees for repairs, they have 3 business days before closing to get it completed. To me, that's not long enough. You have a window in your purchase sale agreement that says a buyer gets a walkthrough within 5 days up to closing. I want to see a 7 or 10 in here to make me feel better. And then the language, if you want me to share it with you, has language in there that if the seller doesn't do this by this time period, then the agreement is terminated, or buyer may terminate, and earnest money will be refunded. So I've added in the who, what, why, where, when, how, and making sure there's a clause that my buyer can get out of the transaction if the seller hasn't done their job, because there's nowhere in this form, there's nowhere on 35R that gives the buyer the language to terminate if the seller doesn't do their job. They can agree to it, but if they don't do it, what happens? A legal battle, of course, but my buyer gets nothing. So it's very important. Did you ride your bike here?
Yeah,
Oh my goodness.
I took the
The light rail. Good, good. Okay. If there's oil tanks on the property, any inspections regarding oil tanks or contamination, which we talked a little bit on the above, from such tanks shall be limited solely to determining the presence or non-presence of oil tank on the property unless otherwise agreed in writing. A seller does not want to know if there's contamination. So again, if your client buying a property with an oil tank on it, and they want to test soil and do all the things, talk to me first before you get too far in it and you all of a sudden now have an issue and a seller is suing you because you gave information, which contamination is a big thing. The seller will be responsible for that contamination for the rest of the life of that property or their termination. On-site septic, buyers advise that the OSS systems are subject to strict governmental regulations. Again, you're going to want to add in one of the septic addendums. This is using only one of the ones that from the many that there are based on county. Please be sure to check the county, making sure you got the protect. So, if your client wants a neighborhood review, then you can check this box. Sorry, there was a bounce back in here. So, what questions, if any, do you have on Form 35, the global version of 35? It is a very important form. I highly recommend that your buyer use it. I know that we're in multiple offers sometimes. The one thing I will say is if you are not going to use this form, buyer, then I want you guys as their broker to use Form 35W because they have to sign their name. They are willingly waiving their right to an inspection. If you're a listing broker and you have a 35W in your contract, and all of a sudden the buyer says, I want an inspection, the answer is no. Granted, we're going to ask our seller, and seller, I'm going to tell you pros and cons of why you would do this, but they made a conscious decision to give you an offer without an inspection. I've had many times where the buyer goes back in and has an inspection. Seller said it was okay. Now they're trying to figure out ways to terminate. They're trying to send the report to the seller to make them come down in price to get closing costs because they've already waived their inspection. They can send me their report. If you ever try to do that, I will probably slap your hand. So make sure that you do not become a dirty little listing broker, buyer broker that does that. So just so you know. So any questions before I move on to the next form? And this is recorded, so I have to be careful because YouTube will mute me.
Hey,
Okay.
Genine,
Yes,
has
Stacy.
any of the 35s, like the response or anything else, have any of those changed?
No.
This is the only one.
This is the only one. And again, it was very minor. It was adding in OSS scope work and that we could actually have bids, even though that's always been the case. They've now put it in writing so they make sure that we know that it's okay. And also really quick, when you are writing language, especially if you have a contractor that did the bid work or whatnot, don't ever put language in there that it's a licensed contractor. Contractors are not licensed. They're registered in the state of Washington, but they don't actually hold a license. They don't have to go to school like we do to get a license. So just know that. But inspectors do, appraisers do, and plumbers, electricians, a lot of those also have to go to school, but just know that a general contractor does not have to go to school. They might be handy, but they don't have to go to school.
Okay, thank you.
You're welcome. Okay, our next form, let's blow you up. Okay, is our 22A. Again, this is a contingency. It's an important contingency if the buyer has to get a loan to buy the house. There are many times you will see it as a listing broker that buyer may not want to use a financing contingency. They might tell you that they're very confident that they can get financing. Maybe they will increase their down payment to help with appraisal issues. Maybe they will use a Form 22EF, evidence of funds, to disclose contingent funds. Because remember, if you do not know, one of the most important paragraphs on the purchase and sale agreement is page 2, paragraph A, purchase price. It states that the buyer is not relying on contingent funds. Even if they use a 22EF, that will protect you if they're trying to get out of the contract because they're getting a gift from grandma that grandma decides they don't like that grandchild anymore and they're not going to give the gift. This buyer will now be in trouble based on paragraph A of the purchase and sale agreement. So, some things that are important in here. One of the biggest changes was right here, and I will talk about that. But let's just kind of go through paragraph A really quick. So this is a contingent upon the buyer obtaining any of the following types of programs or loans. What I like to point out is if they're doing a down payment program and all of the money is coming from that grant, let's say, then you do not have any money that the buyer is physically putting down. The only time you fill out the dollar figure or the percentage is if that money is in that person's U.S. financial institution that they can write a check for to be able to give for their down payment. If they're putting no money down out of their bank, then these become zeros or one of them. You don't usually check both. Please check only one box. Now, buyer may, 5 days is the default, within the first 5 business days of mutual acceptance, they may visit and talk to and apply to as many lenders as they want, unless they fill in this box here. So the big change for here is that if this is filled in with a lender's name or institution, let's say it's ABC Mortgage, this 5 days goes away. They do not have 5 days if this is filled in. So listing brokers pay very close attention because this has happened to me more than once in my lifetime. I get an offer. It's got a pre-approval letter. Maybe even that lender called you to tell you how fabulous their client was, that you should pick their offer over somebody else's. And then all of a sudden you get close to closing and it isn't that bank. It wasn't that lender at all. Fill this in if you want to make sure that the buyer sticks with the lender that they have. I have gotten so many calls over the years from you guys stating, well, the buyer wants to change to this lender. We actually had a doozy of a one the other day in the Kirkland office. Seller took the offer because it was fabulous. No, let me take that back. We're the buyer side. Buying new construction. And all of a sudden, buyer's mom goes into her local bank and does her little thing at Chase. And Chase says, oh, and she mentions, oh, my child's buying a house, this, that, and the other. Well, the Chase person says, oh, you've got to talk. I'm a mortgage broker. I could help your children. Have them call me. So then I get the phone call from our broker saying, I need help changing because Chase says they can give them a better rate. So I dive in a little bit deeper, and you should do the same thing as well. If our buyer ever wants to change a lender that they can't, number one, the lender was the builder's lender, and giving them, I want to say $35,000 to help buy down rates, this, that, and the other, and brought them below 5%, which is fantastic. There is no way Chase could have done that for them. Because builders need banks to help buy properties, they will give certain incentives that's legal to buyers when they come along if they use this particular lender to make it all happen. So if this is filled in, there's no changing it within that 5-day window, like I said up here.
Janine, if
Yes.
you don't fill something in there, so you don't put ABC Mortgage, but you send a pre-approval letter, because this
Mhm.
just happened to me yesterday.
Okay.
Does the pre-approval basically fill this in? Or
No.
if they want to, can I use a change of lender form if they so choose?
So that does not negate the buyer's 5-day window. As you can see, not applicable if not filled in. So it has to be filled in.
Okay.
So if the listing broker didn't change that or fill it in and you're mutual, then your buyer has the 5 days.
Okay. All right. Just making sure. I wasn't sure because I didn't send the pre-approval letter with the offer because I was scared that they were going to get roped in. I mean, hopefully they'll just keep with the same person, but
If I were the listing broker, I would tell my seller this is why I think this should be filled in. If you send a pre-approval letter, I'm filling that in.
Okay.
Because
should go back and
I
check.
want their feet to the fire.
Right. Okay, thanks.
Okay, you're welcome. If for some reason the buyer makes application with anybody and you're 10 days down the road, so neither of these boxes now apply, and all of a sudden they cannot get financing and you receive a termination, don't send a 51 to terminate based on financing ever, ever, ever again. Area 51 is a bad area. Form 51, 99% of the time is a bad form. So don't use it unless you talk to me first. They have to get a letter from the lender that states the reason of non-financing available. They have to, on that letter from the lender, it has to also say that they had sufficient funds to close. Nowhere on here said gifts, it was contingent upon anything. Again, 22EF is not a contingency. It is a pure disclosure. That's all it is. It does not protect your buyer whatsoever. And the date of their application. So based on this number here, or if this is filled in, what was that date of application? And buyer has two choices about their contingency. There's 2A and 2B. 2A is buyer friendly, 2B is seller friendly. 2A says the seller has to ask me, the buyer, to waive my financing based on the number filled in here. Default is 21 days, okay? And they will send that to me with a 22AR. And the buyer now has a choice. Buyer says, yes, I will waive, and signs the form. Buyer says, I don't want to because, just a little nervous hearing about some of that scuttlebutt at my company, some layoffs coming and this, that, and the other. I don't feel comfortable right now signing that. So then the seller has a choice if there's a no answer. If they say, I don't want to waive it, the seller can terminate the agreement. Buyer's protected by this. Buyer will get their earnest money back if the seller terminates. Or seller can say, you know what, we're 3 days, 4 days, 5 days before closing, whatever it is, 10 days. I don't want to go back on the market because I was on the market for 120 days and whatnot. I'm going to let that ride. So those are the seller's choices. And then, of course, appraisal will or will not be also waived based on if buyer waives their financing. 2B says on this date here, 21 days later, as a default, it automatically waives unless day 19, buyer serves notice, not notice, but termination or notice of a failure to obtain financing. If buyer does that before a time period and they've legally done it and they've done all the steps, then the deal will die and buyer gets the earnest money back, but it has to be done prior to the days here. And again, it has the same will or will not waive appraisal. Closing costs, 0 if filled in. So if the buyer needs closing costs from the seller, you can do a dollar amount or a percentage amount. If the buyer is not waived and is unable to obtain financing by the closing date, then on buyer's notice before the closing date, on or before, notice that on or before, that is one of the changes in here. It used to say this survived closing. If I was still trying to get financing and closing is today, and I'm still trying by tomorrow and still trying by Friday, I'm trying to get on Monday, then I would be able, if I got it or not, or I could terminate based on that. And they took that out. It cannot go past closing. So that is a change that they did on this form. The earnest money shall be refunded to the buyer as a consequence of buyer's failure to obtain financing only if the lender confirms in writing to seller within 20 days of the date of buyer's termination. So if the lender gets persnickety and hasn't sent that letter, buyer and seller are now fighting over earnest money. The lender has 20 days to get that to the seller. That's also a change that they added in here. So if you're on day 21 and buyer didn't do this properly, goes to interpleading to fight, duke it out on the earnest money, more than likely the seller will get the earnest money 99% of the time. Okay, so that was also a change. And it says here what you have to give: the date of the buyer's loan application for the property that it was made for, including a copy of the loan estimate that was provided to the buyer. Also, that buyer possessed sufficient non-contingent funds to close, examples, down payments, closing costs, and such. And the reason buyer was unable to obtain financing by closing. If the seller terminates this agreement, the earnest money shall be refunded. So if seller terminates, great. If the buyer does, we might have some problems. And then, of course, there's the appraised value. If it comes in at value, if it comes in higher, great for your instant equity for your client. But if for some reason it comes in low, then the buyer has a choice of saying, I want the buyer sends the notice, the 22AN to the seller. Seller has a response within 10 days after buyer's notice of low appraisal to say, hey, I want a reappraisal or reconsideration of value. I consent to reducing the purchase price to an amount not more than the amount specified in the appraisal. I propose as a seller to reduce the purchase price to an amount. So let's say it's a $20,000 gap. I will do $10,000. Buyer, you come up $10,000. And then seller's rejection of the buyer's notice of low appraisal. So those are their options. If the seller timely delivers notice, except for FHA, VA, and USDA, and the lender accepts seller's response, then the buyer shall be bound by the seller's response. If I do, I reappraise or have reconsideration that I pay for as a seller, it comes in at value, buyer's now bound to move forward. Unless I'm a USDA, VA, or an FHA buyer, same with the amount reduced on either of these. Then buyer can reply on what they want. Buyer shall have their time of rejection of low appraisal, or if the seller fails to respond the day the seller's response period ends, whichever is earlier, waiving financing, terminating the agreement. In that event, earnest money will be refunded to the buyer. Goes through and tells you all of your options. If you're a VA buyer, then there's a high likelihood you're going to have to sign an amendatory clause. Both you and your buyer will have to sign that. Any questions on financing? Great. On to 22VV Victor Homeowners Insurance Addendum. This is a great form for both a buyer and a seller. And so to you listing agents, what I tell sellers and why this is important, we have one, a buyer has to make application for their binder, their home insurance binder, within a certain time period, if this form is used. If not, buyer could wait closer to closing, and then all of a sudden you find out the home can't get insurance. And that is a legal recourse for a lender to deny financing. The deal will blow up and die. We want to know now if it's going to blow up and die versus 3 days before closing. So this is why this is an important form for also our sellers. So this came about for a number of reasons. Because of the forest fires that we've had, both locally and California, and most places, and flooding for that matter, insurance companies are calling our clients and telling them that their insurance is being canceled. They've lived in this home for 20 years, but they have a propensity to have a forest fire based on where their house is. So some insurance companies are canceling policies, especially if you're up in the Suncadia area, Leavenworth, those areas. Very hard to get insurance, or they're just straight up canceling the insurance you've always had. So this has a lot of defaults in it. One is that it cannot exceed half of 1% of the purchase price, and that the deductible cannot exceed $2,000. Don't make these numbers unattainable. Okay. I don't want to see, 0 or $500, those types of things. These numbers are reasonable. And if you don't want to change them, you can leave the default. I'm not a big fan of leaving blanks because of defaults, because there are some blanks that aren't defaults, and that's how sometimes we don't get paid. So leaving blanks is not my favorite. If you like the default, that's what your buyer wants, just fill in the number of the default, okay? You can have additional coverage by buyer's lender for additional coverage is required by buyer's lender, flood insurance, landslide, Woodby Island, Bainbridge, those types of places, earthquake. And if you can think of something else you want to put in there, it gives you a blank to figure out what other kind of insurance you want to have. Buyer shall make the application within 5 days. That is the joy for the seller. If buyer fails to timely make application, then this contingency is waived. So if they can't get insurance, they can't get financing. This is waived because of that. They would be at risk of their earnest money. Buyers pay attention to that. This contingency shall be deemed waived unless within 15 days of mutual acceptance, buyer gives such notice. The earnest money shall be refunded if they cannot get it later than 5 days following buyer's notice of termination based on the homeowner's insurance contingency. So again, this is another contingency. As you'll notice, All of our forms, except for the last one today, will be based on the fact that these are contingencies. I do have a lot of non-Keller Williams listing agents saying they want this taken out of the offers, and that is a risk. And I explained to the listing agent why this is a benefit to their seller. Many people do not know how important this form is. I will tell you that there is nowhere a seller has to disclose if they have filed a claim against their insurance company. So what happens then? It blackballs the house. It doesn't blackball the person, it blackballs the house. So let's say my dishwasher leaked and I was gone for days, and now downstairs all the floors are ruined, cabinets ruined because it rose so high that it ruined some of my cabinets. My cabinets have to be replaced. That's an expensive bill to pay, and maybe I can't write a check to have that done. I'm going to call my insurance company because that's what I have them for, and I'm going to file a claim for them to fix it. They'll pay for all of the repairs. They'll put me in a hotel while it's being done. They'll give me 2 square meals a day. So that bill is building. This would tell me if the house has been blackballed. So that's why it's an important form for our clients, because Form 17, they don't have to disclose that they filed a claim. That I think is changing, just so you know. I have put in the word with legislation that I want that changed. They are working on it. I think that you have to disclose if you filed a claim on your property. So that's another important reason to use this form. It's not just about earthquakes, being able to get the coverage that you need. But if the house is blackballed, the premiums or the deductibles could be higher for your client, even though it's a completely different insurance company. So that's why this is an important form. Yes, Michael.
Yeah, Gene, can you clarify? This would be for the buyer's agent to request that their buyer put this in. Let's say the buyer doesn't put it in. Would it be incumbent upon the listing agent to counteroffer and request this to be put in?
Good question. I don't know if I would take it that far. I just have to have talking points as to why I'm lobbying for this to be in my purchase and sale agreement to the listing agent so they can have the conversation with their seller. But yes, you would put this in based on you writing an offer for your buyer. But again, if you want to have that conversation with your seller and you want to counter and add this form in, that is completely up to the seller.
One other thing, would this be applicable? Let's say you have an oil tank that's not even decommissioned on site.
Okay.
That could be an issue why you couldn't get insurance, possibly, right?
It
Or not
possibly,
necessarily?
I don't know. That would be a great conversation for an insurance broker. Maybe the house is still being heated by oil. So it really depends. I mean, most of them have been decommissioned prior to closing, if it's not being used.
But if it is,
Yeah.
I'll save that for another day.
Okay.
I just talked to my sister. Her house is still being heated by oil.
Yeah.
I didn't say anything, but I was thinking that could be a problem when she sells it.
Well, yes and no. I mean, if it's an active heat source, that's how they're going to be able to sell it because it has heat. It is, some people have not switched over to gas or electric based on their situation. Especially like I mean, Ballard, some of the older towns, even in Bellevue, the first house I sold had an oil tank. They have now decommissioned it and changed over to gas, But
if that oil was leaking, obviously, into the tank,
if that is leaking, that's the current owner is responsible for the property until there's not an issue, whether you sell it 5 times over or not. So that's a huge issue. That's why some sellers don't want to know if there is contamination. Any other questions about 22VV? Okay, our last form of the day is going to be Form 1A. 1A is our listing agreement, okay? We cannot list a property unless we have this form signed. There is a 1A and there's a 1B, I think it is. 1B says that your seller can procure the buyer and not pay you. Do not use 1B, use 1A. The seller has agreed that this will go into the Northwest MLS, includes a contract to sell, exchange, or contract to exchange, or an option to purchase. The firm needs not submit to the seller any offers to lease, rent, or enter into another agreement other than the sale of the property. So if you get an offer that says, I want to rent this for $3,000 versus buying it for $600,000, you do not have to present that to your seller. That is what that's what this paragraph states. I would recommend you still take anything that you have to your seller, but again, that is not against the rules. Otherwise, if you get an offer on a property and whether you like that offer or not, you are required by law to present that to your seller in a timely fashion when reasonably possible. So don't hold on to it for 2 days. You present it when you get it. As an example, with multiple offers, I will, when I get if I'm in that position, the minute I get it, I change the subject line to offer number 1, offer number 2, offer number 3, and I immediately send them to my client. That is also how I keep them mentally in my head to know when I'm creating my multiple offer spreadsheet, who is what. Okay. I don't redact anything from that. It is our client's right to receive everything we receive. So if your client ever asks you for something, text messages from another broker, whatever, on their property, you are required to give it to them. And really quick, let me go back to the Form 35R. If you are a listing broker and let's say you're a buyer broker. If you're a buyer broker and you've sent 35R over to the lender and escrow because there was a price change, and all of a sudden the lender comes back to you, hey, can we get that put onto a 34 so I don't have to give the 35R to my lender? That is mortgage fraud, lending fraud. You will be subject to federal charges, which means you're in an orange suit instead of your cute little black suit that you go out on the town with. So do not go to federal prison because of lender fraud. If any lender tells you to make changes because of that, I want to know immediately. So I wanted to make sure I got that in on this recording as well. Okay. Term: seller hereby grants the listing firm the right to list the property exclusively. So they can't list with somebody else. They can only list with us. And that it will go till the midnight of whatever the date is here. So this is your end date. So we're going to list tomorrow and it's going to expire 6 months from now. So you put 6 months out, whatever that date is, or 3 months, 2 months, whatever you agree upon. But the end date goes here. Of course, we're giving the pamphlet of real estate brokerage in Washington that's already in our disclosure packet. So your client, if they sign a 1A and they don't sign the disclosure packet, they should be done together. Do not ever disconnect both of those. I want my client to sign the disclosure packet as soon as possible. One, that protects you. Number 2, it's simply disclosures. It doesn't bind your client to anything. So if I'm talking to my seller, Mr. Seller, and I tell them that hey, thanks for meeting with me today. They've not signed the 1A, or they're not going to sign the 1A yet. I am going to immediately send my disclosure packet to them and have them sign it so that I've done my job. The minute we offer brokerage services, we are supposed to disclose this pamphlet to them. Back in the old days, we just handed it to them or had them initial and took a picture of it so that we had proof. The listing firm appoints you. Whatever your name is goes here. So the firm is appointing you on their behalf to list the property. It creates an agency relationship with the listing broker and any firm's managing broker who supervised them, which is me, unless you're on a team, during the listing term. If your seller is okay with you being a limited dual agent, they must initial here, okay? I am not a fan of dual agency. I will never do dual agency, and you will never do dual agency when you're involved in the transaction as the principal. The principal is the buyer or the seller. So if you're one of those persons in the transaction, you cannot be a dual agent. It's not allowed. If the property is sold to a buyer represented by one of the firm's brokers other than the listing broker, your designated broker becomes the dual agent. So they cannot unconsent that. Okay. I have to be able to be a dual agent otherwise. And it used to be that they could say they didn't want dual agency. And then that said, I couldn't be a dual agent. So they had to make some changes. The firm shall submit the listing, including the property information on the attached listing input sheets and photographs, images, videos. This was part of the stuff that was added. Virtual tours, drawings, renderings, sketches, floor plans, and other representations of the property to be published by the multiple listing service on this date. That's your live date. It used to be that you had to have it done by 5 p.m. They took that out. So if you get it done later, that's okay. But make sure it's not after midnight because this is your live date. You cannot have them sign this form more than 90 days before the live date. So if you try to go 120 days and they've signed it, you're going to have to redo your paperwork. It's not allowed. It's not legal. Fair housing. Of course, we always have fair housing language in our contracts. Compensation. This is compensation that the seller has agreed to pay to any parties or multiple parties. So you are going to put the amount that the seller's paying us, our listing firm, that means you here. If the buyer is not represented by a buyer brokerage firm, then the compensation shall be this. If you leave this blank, this is the max you're going to get. In the listing part as well, buyer brokerage firm compensation, seller acknowledges that offering any, and then, this will happen with dual agency. So then we have our buyer broker compensation, buyer brokerage compensation. Is the seller going to pay anything to a buyer brokerage? Then they can put that here. So seller's offer of compensation, seller offers buyer brokerage compensation as follows, whatever the amount is here. If the listing broker is a limited dual agent and represents both parties, then you have a number here. And that one can get tricky if you are a limited dual agent, because you'll also have your buyer brokerage your BBSA, your buyer agreement. People get hung up weird and make up weird numbers when it comes to both of these forms combined. So make sure you call me if you have questions. It can be very confusing, just so you know.
It shouldn't be over 6% though.
It's whatever the seller wants to pay. Yep. Remember, there's no standard of compensation. So, and we are not in control of compensation from the brokerage standpoint based on the language they changed last year or the year before. Buyer brokerage compensation shall be paid as set forth as above.
Janine, can I interrupt you real quick just on this? So we're the listing agent. Obviously, we're talking about this form. We have a open house and a buyer comes in and they're like, we really love this house. We want to go ahead and make an offer, but I'm not a dual agent. Can I refer to someone in my office or another agent and get a referral off of that?
Absolutely.
Okay.
Now, with doing that, you will have to make a change. Trying to see where that. Okay. You will have to make a change because you will not have probably checked this box, because now we have to disclose if we're getting referral fees from any party. So you will then have to get a Form 18, have your seller sign that saying that this is now, or you are getting a referral and how much it's going to be.
Can you go back if your seller says, I'm comfortable with you being a dual agent and doing both sides? Can that also happen?
Can you go back and have this form changed?
Yes.
Yes, you could do that.
Okay.
That's fine.
Okay.
But this is why I don't like to change existing forms, why I like to add new forms, because my language in there would be one, now I'm getting a referral fee of X based on this buyer only. Because let's say you're not getting a referral fee. So that way it's specific to a situation and spotlighted versus it's just like a buyer agency agreement. Like I sometimes will make it specific to a property so that it doesn't change my whole agreement. So it's kind of similar to this.
Okay. All right. Thanks.
Yes, you're welcome. If checked, the offer to pay buyer brokerage compensation shall extend to licensed brokerage firms who are not in our MLS system. So maybe somebody from the Yakima MLS, is the seller going to pay them? They don't necessarily have access to our MLS, don't really know what our MLS says. And you have to remember that we publish the amount that the seller is paying a buyer brokerage in our MLS system. In Yakima, they don't. Any NAR office, or excuse me, owned MLS, they do not publish compensation paid by the seller to the buyer brokerage firm.
That would apply if somebody's buyers in Texas, for instance, that wants to buy a place here, the broker called and submitted an offer.
Well, they can't submit an offer if they're only licensed in Texas. They have to be licensed in our state. Yeah. Or the seller can say, I want the buyer to request compensation in their offer. I don't want to disclose that I'm willing to give them X%. I want them to ask for what they want me to pay their broker. Or they can say, I'm going to offer no compensation. And both of these boxes checked will reflect in nothing published in the Northwest MLS. I will tell you, having the conversations about these three options with your seller is hugely important. You can also say how these two boxes might hurt the listing. And if a seller asks you, well, how much should I offer? Well, it's really up to you, seller. What I can tell you is I'm happy to open up the Northwest MLS and show you, based on all the listings in your neighborhood, what the other sellers are offering. It'll show the amount they're offering, if they're asking for it to be requested, or if there's no compensation. If that helps you make your decision, that's I can be happy to do that. So those are some conversations that you can have with the seller as well. The seller shall, within 180 days after the expiration of the listing term, sell the property to any person whose attention it was brought through my marketing efforts. I have a 180-day tail provision, that's what this is called, for the seller to pay me, because let's say they get a call, the listing has now expired, and all of a sudden ABC Realty calls and says, hey, I've got a buyer who came to your open house 3 months ago, and they've decided they want to make an offer. I'm protected and will get paid based on this tail provision. It'll be very hard for a seller to say, well, I came through my marketing efforts when the seller didn't market, right? So that reminds me, maybe it's in here. Okay, perfect. So that's the tail provision. Unless the seller has now listed with a different company and what they offered that listing firm versus my listing firm, if there is a difference, then they do have to pay me. If they're offering, more compensation here than they did on my listing agreement, then they will have to pay me the difference. So the seller will have to pay the full amount to one listing firm now, as well as partial to me, unless they're the same amount. They're the same amount. I charge 3, they charge 3, and they're now listed with this brokerage over here, I will get nothing. Okay, that tail provision goes away if they relist with another firm. Okay, even if the buyer came through my open house 3 months ago. Okay, so that is what that states. Yes.
Sorry, for some of these extra questions. Let's say let's say you receive an email from your buyer saying, I want to use another firm, and let's say you have a 6-month buyer broker service agreement. What is your response? Can they do that? And do we have to obligate it? So you have a 6-month contract.
Yeah.
You want to get out. Your buyer for some reason wants to get out of their contract.
It's just like a listing agreement. You do not have to cancel it.
Okay.
Will you? Probably, because you don't want to have them, you don't want an adversarial position with this client, and it could be a valid reason, but sometimes what happens is, and just remember, as a listing broker or a buyer broker, you can never solicit business from somebody that is in an agreement with either a buyer brokerage or a listing brokerage. Okay. That will cause you few $1,000s to be paid to the Northwest MLS. We can never solicit business from somebody that's currently under an agreement. The words you can use is, once your contract expires, I'd be happy to help you. You can never use the word cancel.
Genine, for the record, that did not happen to me, and hopefully it won't happen.
Good. Referral fee. If the client is referred to you by another company, you have to disclose the listing firm is or is not obligated to pay a portion of my compensation to another firm based on a referral. Listing firm shall install a key box on the property that holds a key to the property, which may be opened with an electronic device, which is our cell phones. Huge disclosure, huge disclaimer. 1, never ever give your phone that has your Supra app on it to any party to use on your behalf. That will land you around $10,000 charged by the Northwest MLS, just so you know. And if there are extra keys in the house, please grab them. Remote controls, if it's a vacant house especially, grab all keys and remotes and put them in a nice little bag, label who it belongs to, because people will come into open houses and say, oh, let's see if this is a soft close drawer. And they see keys and they take one, and then they come back later and steal all your staging. True story. So take those with you, please. If there is a non-MLS broker, so a non-Northwest MLS broker that wants to see the property, does the seller allow that? And they authorize it or don't authorize it? And how are they going to get in? They can't read your Supra box, so I recommend you go with them. So having this conversation with your seller is also hugely important. Never put a contractor box on for this reason. That is a huge liability, and you will probably get sued, especially if the seller did not give you permission to do so. They authorize us to publish it in the Northwest MLS and distribute the listing information and photographs to other members of the MLS and their affiliates and third parties for public display and other purposes, subject to any restrictions imposed by seller. This authorization shall survive the termination of this agreement. Firm is authorized to report the sale to the Northwest MLS as well. The seller may not do their own marketing of the property once the 1A is signed. Okay, so we, as you all know, if some of you haven't heard or someone hasn't told you, we've now partnered with Zillow for pre-marketing of our listings. Number one, it's still a Northwest MLS violation, so do not do it. That will land you in MLS fine jail. And number two, come June, it will be illegal in the state of Washington to pre-market any property. Okay, so a seller cannot pre-market their own property once a 1A is signed.
So they can't post anything on social media.
Not if it's not live. It has to be live and they can do whatever they want. Same with you. Can be live, be respectful and responsible, but once it's live, then you can start promoting. Remember that in for sale sign in the yard 2 hours before it is live could land you in fine jail, FINE, with the Northwest MLS. So paying attention, lockbox on earlier than going live is also another violation of the Northwest MLS, will land you with a fine. If for some reason, this is how I normally do it. When I list a property, I have the sign post installed and I usually take my own sign and I put it on. If Sign Pros has my sign and they install it, they have installed it early before and you will have to run as quickly as you can to that property and grab it, or unless your seller is at the house and they can grab it and put it in their garage. That happened to me last year. They put it up, said they'd put my sign on the side of the house. They actually have a box you can check for this now with Sign Pros. They didn't do that. So I could have gotten myself in trouble. Thank goodness my seller was home, grabbed the sign, put it on the side of the house for me. Completely legal. If for some reason the lockbox is not on, because it can't be because we're not live yet, go into showing time and block out an amount of time for you to be able to get to the property and install the lockbox. Don't ever put in agent remarks, lockbox to be installed at 2 p.m. today. Block it out at showing time. That way they can't show it. And then go out and put on your lockbox. Make sure that the seller has contacted their insurance company to let them know that they are on the market. People have broken into our lock boxes, gone into the houses, have stolen, take staging materials, everything. So make sure that they have put their insurance company on notice. Very important. And the seller warrants that they have the right to sell the property, that it's not a short sale, it's not going to auction, it's not a foreclosure, and that this is not a distress conveyance, and making sure that that is understood. If they are close to a distressed property, give me a call, we'll walk through it. That I can help you with some additional help. Seller will fill out Form 17 completely unless they are exempt. There are 3 exemptions. Bankruptcy trustee, they are exempt. A true estate sale, not a trust, a true estate sale. And if it's subject to a public offering statement, new construction condominiums, that's what that's for. Sellers, does someone have a question? All right. Seller shall furnish and pay for the buyer's title policy. So when the buyer pays for title, they're paying for their lender, but seller is going to pay for the buyer. Seller will pay half of their escrow fees. Buyer will pay the rest. In the event of damages, seller retains earnest money as liquid damages of buyer's breach. Do they get all of the earnest money or do you get half of it? So think about that, as some of the sellers can be a little contentious with maybe how you market the property and they end up firing you and you get nothing. So think about that as you're going through this form with your client. In the event either party employs an attorney to enforce any terms of this agreement and is successful, the other party will pay those reasonable fees. And then of course, any venue will be of a suit will be in the county which the property is located. So don't list a property in Yakima and then all of a sudden you're getting into a lawsuit. Now you got to go to Yakima all the time to plead your case. So any questions on 1A? Well, that is all I have for you guys today. Yeah, 1 more minute. I'm going to let you out of class early. Again, please send me a text if you want the language for attaching bids to a request on a 35R for inspection contingency requests for repairs. Have a great day.
Will we have access to this video?
Yes, once this is properly finished, I send it off to corporate. They will upload it onto the hub and then you can access all of my videos from there. The only time that doesn't work is if I said something that YouTube didn't like and they ban me from that one video. So I try to do my best not to use expensive shoe names when it comes to seller and buyer's names. Wonderful. Well, you guys enjoy the rest of the day. Feel free to reach out at any time if you have any questions. Thanks all for coming.
Yay.
Bye.
Thanks, Janine.
You're welcome.
Thanks. Bye.
Bye.